This Honorable Court, haven't listened to the application. I haven't listened to counsel adopt their respective final written addresses. Will deliver a ruling judgment shortly.
As the court pleases.
As the court.
Judgment.
As the court pleases. Hello.
The defendant, Simi Dranby Augustine, stands charged before this Honorable Court for the offense of procuring or recruiting a person under the age of 18 years to be subjected to prostitution or other forms of sexual exploitation, contrary to and punishable under Section 16 sub 1 of the Trafficking in Persons Prohibition, Enforcement, and Administration Act 2015. The defendant pleaded not guilty to the charge, thereby putting the prosecution to the strict proof of the allegation against him. In proof of its case, the prosecution called 3 witnesses, namely PW3, the investigating officer from NACTIP, PW3, an officer of the Hisba Commission, PW2, an officer of the Hisba Commission, and PW1, the mother of the victim. The prosecution also tendered the extrajudicial statement of the defendant, which was admitted in evidence after the court overruled the objection raised against its admissibility. The defendant testified in his own defense and closed his case. Now, the issue for determination, having considered the evidence before the court and the final written addresses of learned counsel, the sole issue that arises for determination is whether the prosecution has proved beyond reasonable doubt that the defendant committed the offense charged under Section 16 sub 1 of the Trafficking in Persons Act 2015. The law is settled that in a criminal trial, the prosecution bears the burden of proving the guilt of the accused person beyond reasonable doubt. This duty flows from Section 36 sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, and Sections 135 and 138 of the Evidence Act. Proof beyond reasonable doubt does not mean proof beyond every shadow of doubt. It means proof that is cogent, credible, and compelling enough to leave the court with moral certainty to the guilt of the defendant. See Bakari versus State, 1987, 1 WLR, Rocha versus State, 2011, 6 NWLR, Afolalu versus State, 2010, 16 NWLR, Dairo versus State, etc., etc. Once the evidence led by the prosecution establishes all the essential ingredients of the offense charge, the burden placed on the prosecution is discharged. Section 16 sub 1 of the Trafficking in Persons Prohibition, Enforcement, and Administration Act 2015 provides that any person who procures or recruits any person under the age of 18 years to be subjugated to prostitution or other forms of sexual exploitation with himself, any person or persons, either in Nigeria or anywhere else, commits an offense and is liable on conviction to imprisonment for a term of not less than 7 years and a fine of not less than 1 million naira. From the provision, the prosecution must establish 3 ingredients. 1, that the defendant procured or recruited the victim. 2, that the victim was under the age of 18 years. And 3, that the procurement or recruitment was for prostitution or other forms of sexual exploitation. It is also the law that the prosecution may prove a criminal charge by any 3 recognized methods. direct evidence of eyewitnesses, circumstantial evidence, or the confessional statement of the accused person. See Emeka versus State, 2001, 14 NWLR, Igbenovia versus State, 1981, Supreme Court, and Lori versus State, Supreme Court. Where circumstantial evidence is relied upon, it must be cogent, complete, compelling, and unequivocal, leaving no reasonable inference other than that the accused committed the offense. See Abukoya versus State 2016 LPLR, Sambo versus State 1993, etc. The law on confession is equally settled by Section 28 of the Evidence Act. A confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed that crime. A voluntary confession, which is direct, positive, unequivocal, and consistent with other proof facts, may ground a conviction. See Yusufu versus State, Hassan versus State, Omojo versus Federal Republic of Nigeria, Jegede versus State, 2001, etc., etc. A court may convict on a confession alone if it is voluntary, clear, and positive, although it is desirable to look for some evidence outside the confession which makes it probable that the confession is true. Where a confessional statement is challenged, denied, or retracted, the court is enjoined to test its truthfulness by applying the well-known test in R versus Sykes, 1913, Kanu versus King, 1952, Workers 30, and applied in numerous decisions of the appellate courts, including Alao versus State 2019, Junaidu versus State 2021, Supreme Court, Sani versus State versus Sani, Ibrahim Fabi versus State, LPLR, Supreme Court. The questions are whether there is anything outside the confession to show that it is true, whether it is corroborated, whether the facts stated in it are true, so far as they can be tested, whether the accused person had the opportunity of committing the offense, whether the confession is possible, and whether it is consistent with other facts ascertained and proved at the trial. On the number of witnesses, it is tried that no particular number of witnesses is required to prove a fact unless a statute specifically so provides. See Section 200 of the Evidence Act and cases of Babuga versus State, 1996, NWLR, Ali versus State, 1988, NWLR, Simon versus State, 2016, LPLR, Supreme Court. Thus, the prosecution is not bound to call a host of witnesses once the evidence is called is credible and sufficient. The failure to call a particular witness is fatal only where that witness is shown to be indispensable and the evidence on record leaves a material gap which cannot otherwise be filled. See Saleh versus State 2016, 3 NWLR, Itu versus State 2016, Noeke versus State 2017, and Lawal versus State 2025, LPLR, Supreme Court. On contradictions, not every inconsistency in the evidence of the prosecution is fatal. It is only a material contradiction which goes to the root of the charge and creates a reasonable doubt that may be resolved in favor of a defendant. Minor discrepancies, especially those which do not affect the substance of the case, do not destroy otherwise credible evidence. See Nasamu versus State, 1979, Supreme Court, Ogwala versus State, 1991, NWLR, Afolan versus State, 2018, NWLR, Federal Republic of Nigeria versus Kayode Bekele, 2020, NWLR, etc. Now, in evaluating the evidence before the court shows that the defendant knew the victim, Salamatu Idi, through a third party, and thereafter established contact with her by phone. In his extrajudicial statement, the defendant admitted that he took the victim to his house and had sexual intercourse with her. He did not make a single isolated admission. He stated that he had sexual intercourse with the victim on several occasions in his house. He further admitted that on 7th November 2024, the victim came to his house at about 11:00 hours, and that they were having sexual intercourse when the door was knocked and the matter was discovered. These admissions are clear, direct, and positive. The defendant also stated in the same statement that the victim told him she was 15 years old. The statement was made by the defendant himself and was admitted in evidence. The court had earlier considered the objection to its admissibility and overruled, saying the defendant, while testifying, did not materially disown the central facts contained in the statement. Is the defense, rather than displacing the prosecution's case, substantially confirmed that the victim came to his house, that they entered his room, that the room was locked, and that the victim had been coming to his house. The court is therefore entitled to rely on the statement together with the oral evidence of both the defendant and the other prosecution witnesses. On the issue of age, I've carefully considered the argument of the defense that the prosecution failed to produce documentary proof of the victim's age, and that there were alleged inconsistencies as to whether the victim was 15 or 21 years old. The law does not impose only one mode of providing age. Age may be proved by credible oral evidence, by documentary evidence, by admission, or by surrounding circumstances accepted by the court. In the present case, the defendant's own statement that the victim told him she was 15 years old is an admission against interest. It's not a casual fact. It goes directly to the statutory ingredient of age. PW3, the mother of the victim, also gave evidence connecting the victim with the defendant and with the facts surrounding the complaint. The evidence of PW1 and PW2 as investigators provides further context to the report, investigation, and recovery of the defendant's statement. The alleged statement that the victim at one point said that she was 21 years old does not, in my view, create a reasonable doubt sufficient to defeat the prosecution's case. The court must consider the entire evidence and not isolate a fragment. The defendant, who was the adult male who repeatedly had sexual intercourse with the victim, admitted that she told him she was 15 years old. That admission is significant because it shows not only the victim's age as represented to him, but also the defendant's knowledge or reason to know that he was dealing with a person below 18 years old. The court is satisfied that the prosecution has proved beyond reasonable doubt that the victim was under 18 years at the material time.
As the court pleases.
In reaching this conclusion, I bear in mind the principle that evidence is to be weighed and not counted. The court is entitled to act on credible evidence, which it believes, and it is not every discrepancy that should be elevated into a reasonable doubt. The contradiction that should be elevated The contradiction relied upon by the defense on age is not, in my view, sufficient to displace the defendant's own admission that the victim told him she was 15 years old, particularly where that admission is consistent with PW3's complaint and with the surrounding circumstances of vulnerability, parental intervention, and repeated access by the defendant. See Nasamu versus State, 1979 Supreme Court, Supra, Abokunyaro versus State, 2016 LPLR, Supreme Court. I now turn to procurement or recruitment. The word procure in its ordinary legal sense includes causing, inducing, obtaining, bringing about, or making arrangements for a person to be available for a prohibited purpose. The evidence shows that the defendant contacted the victim by phone, took her to his house, kept meeting her there, and had sexual intercourse with her on several occasions. PW3's evidence that the defendant gave the victim money, induced her, and exercised influence over her conduct was not effectively demolished. The defendant's own account that the victim came to his house repeatedly and that he had sex with her on several occasions supports the conclusion that the relationship was not accidental, casual, or isolated.
It was
a continuing course of conduct arranged and maintained by the defendant for sexual purposes. The third ingredient is whether the victim was subjected to prostitution or other forms of sexual exploitation. The statute is framed disjunctively. It is enough if the evidence establishes, excuse me.
Sorry.
The statute is framed disjunctively. It is enough if the evidence establishes prostitution or other forms of sexual exploitation. Sexual exploitation is not limited to commercial prostitution. It includes the abuse of a position of vulnerability, influence, or inducement for sexual purposes. The evidence that the defendant repeatedly had sexual intercourse with a victim he knew or had reason to know was 15 years old in his private room after contacting and receiving her, and in circumstances where PW3 complained of inducement, pregnancy, drugs, bleeding, and disruption of schooling, is sufficient to establish sexual exploitation within the meaning and intendment of Section 16, sub 1 of the Act.
As the court pleases.
The defense placed heavy reliance on the failure of the prosecution to call the victim. It is correct that a material witness should be called where his or her evidence is necessary to prove an essential fact. However, the law does not require the prosecution to call every conceivable witness or a particular number of witnesses. What is required is credible evidence sufficient to establish the charge beyond reasonable doubt. See Simon versus State, 2017, LPLR, Supreme Court. In this case, the absence of the victim is not fatal because the prosecution has led evidence through PW1, PW2, and PW3, and most importantly, tendered the defendant's own voluntary statement containing direct admissions of the material facts. The explanation that efforts were made to secure the victim's attendance but without success is also consistent with PW3's evidence that the defendant's influence had affected the victim's conduct and obedience to parental control. Applying the authorities on confessional statements, I am satisfied that the defendant's statement passes the test in R versus Sites, Supra. There is evidence outside the statement showing that it is true, namely the testimony of PW3 on the defendant's relationship, the victim, and the circumstances in which the matter came to light, as well as the investigative evidence of PW1 and PW2. The facts stated in the statement are internally consistent and are supported by the defendant's oral evidence that the victim came to his house and they entered his room. The defendant clearly had the opportunity to commit the offense. The confession is possible and it is consistent with the established facts. The court is therefore entitled to attach full probative value to the statement. I've also considered whether the defendant disclosed any defense known to law. His testimony did not deny the sexual relationship. It did not offer a lawful justification for repeatedly having sexual intercourse with the victim. It did not displace the admitted fact that the victim told him she was 15 years old. It did not explain away the evidence that the victim was brought within his control and subjected to sexual acts in his house. The defense, at best, seeks to create doubt from peripheral inconsistencies. Those inconsistencies do not go to the root of the prosecution's case in the case of the defendant's clear and corroborated admissions. The authorities cited by the defense on presumption of innocence and proof beyond reasonable doubt are correct statements of the law, but they do not avail the defendant where the prosecution has led credible evidence establishing the ingredients of the offense. The presumption of innocence is rebuted once the prosecution proves the case beyond reasonable doubt. It is not a shield against conviction founded on credible admissions and corroborative circumstances. See Bakari versus State, 1987, NWLR, Afonolu versus State, Supra, Ibrahim versus State, and Mohammed versus State. Findings. Upon a careful perusal or appraisal of the evidence, this honorable court finds as follows. First, the defendant made a voluntary, direct, and positive statement admitting repeated sexual intercourse with Salamatu Idi in his house. Second, the defendant admitted that the victim told him she was 15 years old, and the court accepts the totality of the evidence as proving that the victim was under 18 years old. Third, the defendant's repeated contact with, receipt of, and sexual access to the victim in his house amounted to procurement or recruitment within the meaning of Section 16, sub-1 of the Trafficking in Persons Act. Fourth, the surrounding circumstances, including inducement, money, repeated sexual acts, pregnancy, alleged administration of drugs, bleeding and disruption of schooling, established sexual exploitation. Fifth, the evidence of the defendant does not disclose any defense capable of raising a reasonable doubt. Now, the sole issue for determination is therefore resolved in favor of the prosecution. I hold that the prosecution has proved the charge against the defendant beyond reasonable doubt. The defendant Simi Drambi Augustine is hereby found guilty of the offense of procuring or recruiting a person under the age of 18 years for prostitution or other forms of sexual exploitation, contrary to Section 16(1) of the Trafficking in Persons Prohibition Enforcement and Administration Act 2015. He is accordingly convicted as charged.
Yes, court, please.
As court pleases.
Any previous conviction?
We know of, we are not aware of any previous conviction, my lord.
Mr. Ndahi, ask the defendant if he has anything to say to the court. Ask the convicts.
Mr. Sini Drambi Augustine, do you have anything to say to the court?
Can you hand him the mic?
Now the court has found you guilty of the charge. You have been convicted. So do you have anything to say? That's to that. Open your mouth and talk so that
I'm pleading with this honorable court that to consider me as an orphan, and the orphan only my mother and my sibling to take care of them. Like I said, I am orphan, and I have only my mother and my sibling. Take care of them. So I want to this honorable court to consider that. Thank you.
Counsel, okay, you still have something more to say? Okay. The defense counsel?
Yes, my lord. As said by the convict, he's the breadwinner of his family, having a mother and a number of siblings under him. My lord, the convict is also in his youthful age. And a first-time offender. My lord, he has also punctually attended his trials. My lord, based on the mentioned facts, my lord, we urge this honorable court to consider our plea, my lord, in mitigation and temper justice with mercy on the convict while passing a sentence. Thank you, my lord.
Also, my lord, from the side of the prosecution, also, my lord, we have this to say on behalf of the victim and her parents. Considering the magnitude of the offense and which caused a serious destruction to the life of the victim and her parents, and also which frustrated her schooling, and the lots of loss that has gone to the side of the parents. We so urge the court to consider the compensation sought by the PW3 in her testimony. May it please the court.
Sentence.
As a court, please.
Section 16(1), sub-1 of the Trafficking in Persons Act prescribes upon conviction imprisonment for a term of not less than 7 years and a fine of not less than 1 million naira. The punishment is therefore partly mandatory. The court cannot go below the statutory minimum. although it retains a sentencing discretion within the limits permitted by law. In exercising that discretion, the court is guided by the established objectives of sentencing, namely punishment, deterrence, reformation, protection of society, denunciation of the unlawful conduct, and proportionality between the offense and the penalty imposed. See also sections 310 and 311 of the Administration of Criminal Justice Act 2015, which required the court, after conviction, to consider any allocators and all relevant aggravating and mitigating circumstances before sentence is passed, which was done. I've considered the gravity of the offense. The offense for which the defendant has been convicted of is not a mere private moral wrong. It is a statutory offense directed at protecting vulnerable persons from sexual exploitation and trafficking-related abuse. The victim was found to be under 18 years. The evidence accepted by the court shows repeated sexual access, inducement, receipt of the victim in the defendant's private residence, disruption of parental control, and circumstances pointing to exploitation. These are all aggravating factors. The conduct was not shown to be accidental or momentary. It was a continuing course of conduct and therefore calls for a sentence that marks the seriousness of the offense and sends a clear message or signal that persons below the age protected by law must not be procured, induced, or exploited for sexual purposes.
As a court, please.
I've also considered the mitigating circumstances as pleaded for by the convict and his counsel. The defendant or the convict stood trial and exercised his constitutional right to defend himself by getting a counsel. There is no evidence before this court of any previous conviction. The court also take into account that the defendants, the convict's extrajudicial statement assisted the investigation by admitting material facts, although he did not plead guilty at arraignment and the matter proceeded to full trial. These factors are relevant, but they do not outweigh the aggravating circumstances or the statutory policy reflected in the minimum sentence prescribed by the Act. The purpose of this sentence must therefore be both individual and general. It must punish the convict for the offense proved against him, deter him from similar conduct in the future, deter other persons who may be minded to take advantage of vulnerable young persons from sexual exploitation, and reinforce the protective objects of the Trafficking in Persons Act. At the same time, the sentence should not be excessive or vindictive. It must remain proportionate to the offense, the circumstances of the offender, and the sentence prescribed by the legislature. Having weighed the aggravating and mitigating factors, I am of the view that the statutory minimum sentence sufficiently meets the justice of this case. The court does not consider it necessary on the material before it to impose a term above the minimum prescribed by law. However, the mandatory fine must also be imposed because the Act expressly provides for both imprisonment and fine. The sentence will therefore reflect the statutory command. the seriousness of the offense, and the need for deterrence, while avoiding an excessive custodial term beyond the minimum in the absence of proven previous conviction or additional aggravating facts warranting a higher time accordingly. The defendant, Simi Drambi Augustine, is sentenced to 7 years imprisonment and shall also pay a fine of 1 million naira to the victim to be held in trust for her by her parents to enable her to complete her school portion to Section 16 sub 1 of the Trafficking in Persons Act. The term of imprisonment shall run from the date of this judgment, subject to the lawful competition of any period already spent in custody in relation to this charge, where applicable. This sentence is imposed after consideration of the statutory minimum, the seriousness of the offense, the protection of vulnerable people, the need for deterrence, and the mitigating circumstances available on the record. This shall be the judgment of this court.
Thank you, my lord.
Please.
We are obliged by the sound and very reasonable and a good judgment so far delivered, considering carefully about the issue concerned at hand. Thank you, my lord. We are so much grateful.
Okay.
Thank you, my Lord. We are grateful for the sound judgments. May you continue to be guided by the Almighty.
Thank you. I'm into your prayers. Yes.
Charge number FSC/DM/CR/15/2026 between the Federal Republic of Nigeria and Keystone Bank, PLC.
Presentation.
May it please, my noble Lord. NT Eco is my name.
Your names again?
NT Eco initials, my Lord. NT initials, Eco is spelled IKO. My Lord, my humble appearance is for the prosecution.
Respectfully, my lord. I'm J. Approve, my lord. My humble appearance is for the defendant, my lord.
Yes.
Yes, my Lord, the case is ordinarily slated today for arraignment.
Yes.
However, my Lord, the Learned Counsel to the defendant visited the prosecution in their office at Maiduguri Zonal Directorate. That was sometimes last week, and intimated.
Just a minute, counsel. You should be aware that I'm recording. So
Ask her, please. It's very well, my Lord. So sorry, my Lord.
yes.
Yes, my Lord. Like I said, Learned Counsel to the defendant has approached the prosecution in their office in Maiduguri. With a view to settling this case out of court, my Lord. And my Lord, after due consultation with the authority concerned we have acceded to their demand. So, my lord, in the circumstances, we earlier on agree that they will contact the defendant's headquarters in Lagos to do the needful. But unfortunately, we were reliably informed that the lead defense counsel was involved in an accident which necessitated the fact that he could not contact the defendants to do the needful.
Counsel, I don't like this needful, that word.
As properly guided, my lord, properly guided, my lord. So, my lord, in the circumstance, we most simply crave their lordship indulgence for an adjournment to enable us fast track the process and report same to this honorable court.
Your last submission again?
Yes, my lord, I say we crave your lordship
You said
indulgence for an adjournment.
time.
Yes, my lord, we need time within which to finish up the process and report same to this honorable court. My lord, we must simply ask for a date in next week, my lord, subject to court convenience. But that's a most humble application.
Any response from the defense? Okay. If there's none, give me a date.
Yes, my lord.
Register.
My lord, we shall be asking for the for the 30th.
Register of court.
Yes, my lord. My lord, we shall be asking for the 30th or 1st of July, subject to court convenience. 30th of June or 1st of July, subject to court convenience.
Registry of court, you are muted. I've been waiting for.
Sorry, my lord.
Sorry, my lord. After vacation, my lord, 17th September, after vacation.
No, sorry, my lord, after vacation is too far. We must normally ask for a date, my lord, before vacation.
Any, Mr. Ndahi, any date before vacation?
Thank you, my lord.
6th July, my lord. July 6th.
6th July.
My lord, 6th July is convenient. 6th July is convenient, my lord.
Okay. This matter is hereby adjourned to the 6th of July, 2026.
Ask for please. My lord, we are most grateful, my lord. Very much grateful, my lord.
You're welcome. Thank you, Counsel.
Yes.
Yes. The next case.
charge number FSC/DM/KR/17/2020 between the Federal Republic of Nigeria and Shaibu Umaru Dogo. The defendant is at the correctional center.
Yes, I'm trying to get.
It is my lord, and be Muhammad PSC for the prosecution, my lord. Thank you, my lord.
With the best of compliment to this honorable court, my name is
Counsel, hold on.
Ibrahim.
Counsel, hold on.
Okay.
I'm trying to bring out the file. I'm yet to.
As a couple, please, my lord.
The correctional center, are they not online? Correctional center, are they not online?
No, I can't see them on the screen, my lord. They have disappeared.
I see.
Yes, they are online now, my lord.
Okay. I've not seen, okay. What is
Good morning, my lord.
correctional center? Okay, good morning, sir.
Okay.
Good morning, my lord.
Good morning. Is that Mr. Ibrahim?
Good morning.
Is the defendant there? Call
We
the.
have not had the call. Sorry, my lord.
Okay, okay, thank you.
Tomorrow, Dogo. FRN tomorrow, Dogo.
Yes, my lord. The defendant is present here at the correctional center and speaks Hausa, my lord.
Okay, thank you.
Thank you.
Representation?
It pleases my lord, and be Muhammad PSC for the prosecution. Thank you, my lord.
Any counsel for the defense?
Yes, my lord, with the best of compliment to this honorable court, my name is Ibrahim G. Labaran. I humbly announce my appearance for the defendants.
Yes.
My lord, the matter was slated today for ruling on our bail application, my lord. We are ready to proceed, subject to my lord's convenience.
The ruling is not 100% ready, so it will be delivered on the 6th of June, 2026.
Yes. That's quite please.
The matter was adjourned for a ruling.
Yes, my lord.
I think it's for commencement of trial.
As a couple.
As well as
please.
because my attention, anyway. Prosecuting counsel, you are not yet ready? Because I have not heard anything from your side.
My lord, I'm ready with one witness, my lord.
Why are you keeping quiet? You are supposed to lead. After your,
Sorry, my lord.
Your introduction, you are supposed to tell the court this is matter is for this. Because what I can see on the court list is matter is for commencement, then slash bail application.
As the court pleases, my lord.
So I do not, because I've not heard anything from you.
Sorry, my lord, with greatest apology. I have one witness before the court, my lord. And I'm ready, my lord.
Yes.
Yes, my lord. My lord, I would like to, at this point, my lord, I would like to inform this honorable court that we are not ready to proceed with the hearing of this matter today. Reason being that first, my lord, we were not yet been served with the facilities by the prosecution in respect of this case. And then secondly, my lord, we prepare.
Can you just counsel?
Yes, my lord.
You have been following proceedings all day. Why are you just talking like that?
My lord,
you want to be on record or what? Or you don't need, or you don't want to be on record?
Yes, my lord. My lord, we are not ready to proceed, my lord. Based on the reason is that, my lord, we want to have a peaceful hearing as we are coming all the way from Kano, my lord, for the hearing of the matter. My lord, we are not well, my lord, prepared for the virtual hearing. Rather, we prepare the peaceful hearing. So we crave the indulgence of my lord to oblige us with another date for peaceful hearing. That is a humble application, man.
If this matter is adjourned for a physical hearing, will you ensure that on that date you ensure that the defendant is brought to court? Because you can see presently the defendant is at the correctional center.
Yes, my lord, what the point I'm trying to make is that, my lord, we will come all our way from Kano, but the defendant can even stay there, but we want to have the witness in the court so that we can have the physical hearing, my lord. That is the point we are trying to make.
Give me a date in there. You are muted. Registry of Court, you are muted.
Yes, my lord. Since we will be taking 6 for the bail application that day, my lord, we will take the proper date for the hearing of the matter.
No. Look at the diary and give me a date.
September 17th, my lord, after votation.
Counsel.
Yes, my lord.
September 17th.
September 17th, September.
Yes, my lord. My lord, if we can be given
Not
opportunity.
you. I'm not talking to you. I do not know why the prosecuting counsel is just silent. Must I prompt you? You are not a junior counsel. Why are you just sitting there silent? This person has just made a submission. You did not say anything. Must I prompt you all the way?
My lord, I conceded to the date suggested by the registry. With greatest apology, my lord. Thank you, my lord.
Down to the, did you say 17 or 27? 17th day of September 2022.
17th September.
Yes,
as the court pleases. With greatest apology, my lord. Thank you, my lord.
Thank you, my lord.
You're welcome.
Charge number FDC/DM/PF between the Federal Republic of Nigeria versus Boko Haram. The defendant is absent now.
Representation.
Yes, my lord. The prosecution counsel is absent, my lord, as a result of the exercises they are in throughout the week, my lord. Based on the letter he sent.
No defense counsel? Online? None.
None, madam.
Give me a date.
As the court believes. 17 September.
Matter adjourned to the 17th day of September, 2026.
As the court believes. Charge number FSC/DM/CR/6 2023 during the Federal Republic of Nigeria versus Sirajo Ali. Defendant absent.
For those that at the correctional center,
Court believes.
CR6.
Charge number. So
No, let's finish with this one first. I'm trying to open the file. Is the defendant on bail?
yes, my lord.
It's not before the court.
Yes, my lord.
Okay. The presentation?
Yes, my lord. The prosecution counsel is absent based on the reason adduced earlier, my lord.
Okay, give me a date.
Justice. 24th September.
2-4.
Yes, my lord.
What adjourned to the 24th day of September 2024. Defendants are to continue to enjoy the bail granted them to the next adjourned date. Yes.
Charge number FSC/DM/CR/27/2026 between the Federal Republic of Nigeria and Shagari Saleh.
This Odachigbo case, are counsel online?
Yes.
Okay, yes. Yes.
Okay, the next one on the cost list is better to call that one first.
Sorry, my lord. Charge number FSC/DM/CR/21 2019 between the Federal Republic of Nigeria and Baghdad Chipo.
Let me just open the file. Yes.
Yes, my lord, the prosecution counsel is absent. The defendant also is at the correctional center, my lord, Bauchi Correctional Center.
Respectfully, my lord, the defendant counsel is online, my lord.
Yes, go ahead.
Respectfully, my lord, MAA Minor. My humble appearance is for the defendant.
Yes.
Most obliged, my lord.
Yes.
Yes, my lord. Honorably, the case is supposed to be for trial, continuation of trial, my lord. I'm not privy to the fact as to why the prosecution is not in court, my lord.
Registry.
Yes, my lord.
Can you inform counsel once again?
Okay. The prosecution counsel sent a letter that they are having a program this week, War Against Drug Abuse. That is why it's not.
Counsel, did you hear that? Defense counsel, Mr. Maina.
My lord.
Did you hear what the registry said, or the registrar
No, my
said?
lord. I didn't get that, my lord.
That the prosecution counsel are having a campaign against drug abuse. That is why he's not in court today. He sent in a letter.
Okay. Okay, my lord, due to the prevailing circumstance, I would like to apply to the court for a date subject to the convenience of the court, my lord.
Give us a date. Registry.
September 24th.
Council, September 24th. Council, September 24th.
September 24th is convenient, my lord.
This matter is hereby adjourned to the 24th day of September 2024 for continuation of hearing.
As the court pleases. Most obliged, my lord. Thank you very much, my lord.
Sender, call the next case.
Court pleases. Charge number FTC/DM/CR/27 2026 between the Federal Republic of Nigeria and Shagari Saleh. The defendant is at the correctional center.
Yes, my lord, the defendant present at the Petition Correctional Center and speaks Hausa.
Okay, thank you. Representation.
Respectfully, my lord, my name is S. Musa. My humble appearance is for the prosecution.
Yes.
Yes. May it please this honorable court. My name is I. Abdullahi. And I assume my appearance for the defendant, madam. Thank you.
S. Musa is for the prosecution.
Yes, my lord.
Okay.
My lord, it is related today for motion, my lord.
Yes. Slated today for
continuation of that small scale application. However, my lord, we have a motion before this honorable court.
Okay. Well, the motion. Yes, continue.
Yes, subject to the court convener, my lord, we are ready with our motion.
Yes.
Yes. My lord, the
Mr.
motion is
Mr. Minor. Okay, it's Abdullah. Okay, so okay,
Yes,
you
my
can go
lord.
ahead because no, it's okay. You are not part of this case because I can't see. Okay, go on.
yes, my lord. My lord, before use a motion on notice dated the 23rd day of June 2026 and filed on the 24th day of June 2026. Subject to the court convenience, we are ready to move same.
Go ahead. The other counsel is not.
Yes, my lord, the respondent have not filed counter to our motion.
My lord, sorry. I have some network issue, my lord.
I see.
Yes. Sorry for the inconvenience. My lord, the case on the court list is for the motion for bail application. Not the said by the prosecution counsel, my lord.
Yes.
My lord.
Leman Musa, can you make yourself visible because you are not visible?
Okay. Yes, can you see me?
Yes.
Okay. Okay.
Sorry, my lord. Sorry, my lord.
The motion is seeking for an order, my lord, granting the prosecution applicant to file and serve an amended summary of evidence, amended list of witnesses, and additional documents to be relied upon at the trial of this case. In the manner underlined in the proposed summary of evidence, here to attach. Two, my lord, an order dealing the said amended summary of evidence, amended list of witnesses, and additional documents to be relied upon at the trial, already filed and served as properly filed and served. And for such order or orders, this honorable court may deem fit to make the circumstances of this case. My lords, in compliance with the rules of this honorable court, the motion is accompanied with 8-paragraph affidavit, enforced by one Usman Mohammed Goje, a prosecution secretary, a
Can you
prosecution
move your
registrar at
application on
the...
terms?
Okay, my lord, thank you. Most obliged. So, my lord, since the respondent is not opposing the application, we only move this application in term and urge this honorable court to grant our application as contained on the motion, on the basis of the motion, my lord.
No. My lord. Sorry, my lord. I have some issue with network. So, as I was informing this court that the prosecution filed the motion this morning and we were served. So the matter on the court list, is not for a motion for the prosecution that was filed this morning. It is for a motion for bail application for the defendant, my lord. So sorry, my lord, for the inconveniences I faced from the network issue.
What I want to find out, even if you're going to move your motion, that other motion by the prosecuting counsel, are you opposing the motion?
No, we are not opposing, my lord.
Your motion there.
I've got places.
The motion moved by the prosecuting counsel being a harmless application is hereby granted.
I've got places.
We are very much grateful.
Yes, my lord. Before this honorable court is a motion on notice subject to the convenience of the court. We are ready to move them.
Go ahead.
Thank you, my lord. My lord, the motion is brought pursuant to sections
Just move in
162
terms.
and 1.
Yeah. Try to move in terms.
Pardon?
Move your application on terms. Yes, go ahead. Exit their counsel.
Yes, my lord.
Mr. Abdullah Suleiman, Esquire. It's like he's frozen on the screen. He's having challenges.
So, my lord, as with regard to the defendant's motion, we have filed a counter affidavit.
You can't. I need to.
Yes, my lord. I'm with the
Okay,
court now.
you are back. Okay. Yes.
The motion is
Counsel, can you move your motion?
Yes, I'm moving, my lord. The motion is dated the 25th day of June 2026.
Quickly, we have so many other cases.
And filed on the 26th day of June 2026, my lord. The motion is supported by a 24 paragraph affidavit.
You are wasting my time, counsel. Move your motion so that I can go on with my other cases.
My lord, and we urge this honorable court to grant our application in the interest of justice, my lord. 24 paragraph affidavit and final address, my lord. We are adopting same as our oral argument and submission before this honorable court, and we urge this honorable court to grant our application in the interest of justice. May it please this honorable court. Thank you, my lord. Yes, my lord. We are in receipt of respondent counter affidavit. We have received the respondent counter affidavit, my lord, dated 24th day of June 2026, my lord. We urge this honorable court to discountenance the respondent counter affidavit and grant our application in the interest of justice. Thank you, my lord.
Yes, my lord. The prosecution, the respondent has filed counter and the 5-paragraph affidavit was by one Usman Mohammed Goje, the prosecution Yusra, the Director of Public Prosecution, Ministry of Justice, Yobe State Damaturu, and the counter affidavit is accompanied by our written address, which is dated the 22nd day of June 2026. And we urge this honorable court to refuse the application of the applicant and grant all our prayers sought in the counter. Thank you.
Give me a date, Mr. Dahi.
You are muted, Mr. Ndai.
Yes, my lord. 17th September, my lord. Sorry.
How many cases do we have on the 6th? So far, how many?
On the 6th. We have about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18.
What day did you, 17th September? 17th,
Yes.
when?
September, my lord.
This matter is hereby adjourned to the 6th day of June, the 6th day of July,
As the court,
2026.
As
The
court,
defendant is to be further remanded at the Potoskum Correctional Center to the next adjourned date.
as court, please.
Or the next case.
An da wannan shari'a na sai ranar 6 ga watan 7 wani sati kenan za a ci gaba da sauraron wannan.
charge number FSC/DM/CR/3 between the Federal Republic of Nigeria and Musa Ibrahim and Abubakar Abdulkadir Bulakos.
Are they present in court?
Yes, they are in court.
Are they still in it at the correctional center? Still more defendants?
No.
None.
We're done with the correctional.
Oh, I see. Okay, Mr. Ibrahim, thank you so much. As well as the staff of the correctional center, thank you.
But
Representation.
May it please, my lord? I remain Z.I. Mustafa, Mrs. Humbly announcing my appearance for the defendant, for the first defendant.
With humility to my noble lord, my name is N.B. Umar. I appear for the second defendant. Thank you, my lord.
Yes.
My lord, this matter is slated for continuation of hearing. However, my lord, the prosecution is not in court. And we have been intimated by the registry regarding the reason behind his absence. My lord, we have no option other than to ask for an adjournment. However, my lord, this is the third time, my lord, the defendant is coming for his trial, my lord, all the way from Dar es Salaam. And not a single progress has been made on the side of the prosecution to continue this matter. My lord, it is our prayer that if at the next adjourned date, the prosecution are not ready to proceed with this matter, we urge, my lord, to foreclose the defendant. The prosecution, sorry. We urge, my lord, to foreclose the prosecution and allow us to open our defense on the next adjourned date if they fail to make any progress. May it please the court.
Yes, my lord. I equally align myself with the submission of the council to the first defendant, my lord. Thank you, my lord.
A date.
Yes, 17 September, my lord.
This case is called the defendants, both defendants are in court. The prosecuting counsel is not before the court. All applications made by counsel hereby granted.
As court pleases.
The 17th of September, 2026.
As the court pleases, we are grateful, my lord.
Charge number FSC/DM/CR/25 2026 between the Federal Republic of Nigeria and Mohammed Aminu.
Yes.
Yes, my lord. The defendant is in court, my lord, and he speaks counsel.
Representation.
Respectfully, my lord, I am A.A. Sharif. I humbly announce my appearance for the defendant.
Yes.
My lord, the case was slated today for continuation of hearing.
Yes.
However, the prosecution counsel is not before the court. We have been intimated by the registry for his absence.
Yes.
In view of the prevailing circumstances, my lord, we shall humbly be applying for a date. Thank you, my lord.
Registry date.
24th September.
This matter is called. The defendant is in court. Matter adjourned to the 24th day of September 2026. The defendant is to continue to enjoy the bail granted him to the next adjourned date.
Thank you, my lord.
Let's call the next case.
Charge number FSC/DM/CL/18/2024 between the Federal Republic of Nigeria and Mala Alhaji Tijani. Mala Alhaji Tijani. Defendant is in court, my lord, and he speaks house.
Representation.
Yes, may it please your lordship. I remain Z.I. Mustafa, Mrs. Holding brief counsel for Bishu Aibu, and humbly announcing my appearance for the defendant.
Yes.
My lord, the matter is slated for continuation of hearing. However, in view of the absence of the prosecution, we'll be humbly asking for a date, my lord, to enable the prosecution appear so as to make progress. May we be guided by the court's diary for a convenient date.
Next date.
Yes, my lord. Same 24th, my lord. 24th day of September.
Okay, sir.
This case is hereby adjourned to the 21st day of September 2026.
As the court pleases, we are grateful, my lord.
For the next case.
That is all for the day, my lord.
Okay. Thank you, counsel, and thank you all staff of the Federal High Court.
Thank you, my lord.
You have a nice day.
Thank you, my lord.
Thank you, my lord.